Well, we've already lost. We just lost more. We went from 1,024 to 1,068.
Oh, we might be live.
Hey, everybody! Welcome to Alien Gear Live here on Facebook and YouTube. Today is Calling the Shots. We have my friend Andrew Branca in the house. Thank you, Andrew, for being here, taking the time. We appreciate that. The law of self-defense. Now, listen, we had, as usual, almost it seems now, a little technical difficulties getting started here. So Andrew's audio should be fine, hopefully. The video might be a little choppy, but I think we're going to be able to pull this off. It's Calling the Shots, where you make the call. We're going to be talking about the law of self-defense. Where are you within the boundaries and of the law? You know what time it is? It's time to fire away. Cheers, Andrew. Good to see you, bud.
Yeah, I like your mug.
Thank you.
Very
I like
pleased
it
to be
too.
back. Thanks for having me on again.
As always, it's our pleasure. We sure appreciate you taking the time to be here with us. So, ladies and gentlemen, first we want to start by telling you there's something that you need to do for these shows. So if you don't already have it right now, we're going to give you a little bit of time. Maybe you could go download this right now, or if you don't, do it after the show. It's the 5 elements of self-defense law. You can get it right here at lawofselfdefense.com/CTS elements. Those are the 5 elements of self-defense law where you are within the boundaries. And this is the first thing you probably need to know. You probably need to do. You can get the download for free right now at that website. And the reason why you should probably do that is we're going to be talking a little bit about these 5 elements. We're going to talk about some other things today as well. But in the future going forward, we want you to have that there so that you can refer to that while we're live. Because those are and also not only that, I mean, that's just one reason. But the main reason is so that when you go about your day-to-day life and you're carrying your firearm concealed in your alien gear holster, and a situation arises, you know the 5 elements that are going to protect you. So you're protected by the law. You want to be within inside those boundaries of the law. So you should have this. You should know this. It should be second nature to you. So I'm giving you a little more time to go get that now. Again, it's lawofselfdefense.com/CTS, means calling the shots, CTS elements. And you can download that, print it out, make sure that you have it with you every Wednesday and get to know that very well. So there it is there. And Andrew, I guess we're going to talk a little bit about these 5 elements. So that's your expertise. And
Yes, indeed. And happy to do that. I do want to reassure people that because everyone will know that every state has its own self-defense statutes, jury instructions, court decisions. So in that sense, the law is different everywhere. But in a more important sense, the underlying principles of self-defense law are the same in all 50 states. So these 5 elements we're going to talk about apply in every one of the 50 states, in Washington, D.C., and all U.S. territories, because the legal doctrines that underlie all those different statutes, jury instructions, and court decisions, those legal doctrines are all the same. And if you go look at your state's statutes, jury instructions, and court decisions, you will find these 5 elements because they are the same in every state.
I'm getting a note here that our audio is off a little bit. Yours is clear, Andrew, but I think we had some technical difficulties. But we can understand you. We can hear you. You're just not matching your lips, which is kind of interesting. So, wah, wah. But we can hear you. We can understand you. I'm just letting you know, everybody, we understand that his lips don't match. Mine probably don't either. But there's still great information here, so stay tuned. Let's talk about those 5 elements of self-defense law. Andrew, I hope you all got yours now. Hopefully you have had time to download your copy and you have it there in your hand and you can refer to that. So, Senor Branca, take it away.
Sure. So just in summary, the 5 elements we're talking about here are as follows: innocence, imminence, proportionality, avoidance, and reasonableness. Now, that's the maximum number of elements you're required to abide by in order for your use of force to be lawful. You may not be required to abide by all 5. There are states and circumstances in which one or more of those 5 elements may not be applied. So you may not even need to abide by 5, but 5 is the maximum. And in that sense, folks, self-defense law is pretty straightforward. You don't need to know 500 legal doctrines or even 50 legal doctrines. Under the worst case scenario, we're talking about these 5, maximum up to 5 elements of a claim of self-defense. And again, they are innocence, imminence, proportionality, avoidance, and reasonableness. And I'll be happy to step through each one of those 5 if you want to jump into those now.
Let's do it.
All right. So the element of innocence essentially has to do with your obligation not to have been the initial aggressor in the fight. You can't have started the fight. Obviously, self-defense is intended to allow someone to use defensive force against an unlawful attack. It's not intended to allow an initial aggressor, unlawful aggressor, to use force against another person and then justify their unlawful use of force as self-defense. What could be more obvious than that? Unfortunately, where people get caught up is in the finer details of what it means not to have been the initial aggressor. In some states, the threshold for being the initial aggressor includes things like not having contributed to the affray. Well, what's that mean? It doesn't necessarily mean not having thrown the first punch. Does it mean that even if you give someone the finger in a traffic confrontation, or you give someone the eyeball on a subway, even though you know that's a sign of disrespect, is that contributing to the affray? Are you helping to kick off that fight? If the people deciding whether or not your use of force was lawful decide that that was enough to constitute an initial act of aggression, contributing to the affray, they can argue that you've lost that element of innocence. And if you've lost that element of innocence, folks, you've lost self-defense. I mentioned earlier that one or more of these 5 elements of self-defense could potentially be waived, so it wouldn't apply in an individual case. The element of innocence is never waived. It's always applied. So if it's deemed that you were the initial aggressor, you've lost the element of innocence. You've lost self-defense as a legal justification for your use of force, period. And something for folks to keep in mind is self-defense is extremely binary. So either you qualify as your force having been self-defense and you have 0 criminal liability, or you fail to meet one of the required elements and you lose self-defense as a justification completely. So either it was lawful self-defense or it was not lawful self-defense. There's no middle ground there. So it's like an old school light switch. Either it's on or off. And if you lose self-defense, folks, another thing to keep in mind is if you're claiming self-defense, it's not because you're saying, it wasn't me who used force against that guy. I was someplace else. I have an alibi. I have an excuse for why it couldn't have been me who used force against that person. If you're claiming self-defense, in effect, what you're saying is, it was me who used force against that person, but I had the legal justification of self-defense. Well, if you're missing one of these required elements, and as a technical legal matter, your use of force was not lawful self-defense, you've lost self-defense. And what's left of that statement? It was me, but I did it in self-defense. If the self-defense portion is taken away, all that's left now is, in effect, a confession. So very important, if you're going to be using force in self-defense and you plan to justify that use of force in self-defense, that you do not lose any of the required elements. And this element of innocence is always required. It's never waived. It's never forgiven under any circumstances. And the threshold for losing innocence can be surprisingly low.
Now, does that go for all 5, Andrew?
No, some of the other elements can be legally waived. Some of them are commonly legally waived. When we get to the element of avoidance, for example, that is a very commonly legally waived element. So it's actually only applied by about 13 states. So the large majority of states don't impose the element of avoidance unless there's some aggravating factor, some odd fact pattern that might trigger it. But as a normal matter, they don't impose a legal element of avoidance. Well, I'll come back to that when we talk about the element of avoidance. So that was the element of innocence. Another way that people can get in trouble is that someone else might be the initial aggressor in a confrontation with you. They might try to throw the first punch, for example, or they might shove you. They may be the first person to threaten or use force, which is really the core definition of who the initial aggressor is. Excuse me. So someone else might have been the initial aggressor, but a non-deadly force aggressor. So the force they're threatening you with, or the force they're using, is not force likely to kill you or cause serious bodily injury. We'll talk more about this when we talk about the element of proportionality. The point is, they might have been the initial aggressor in a non-deadly way. That doesn't entitle you to respond with deadly force. And if you respond with deadly force to a non-deadly force threat, they might have been the initial non-deadly force aggressor, the first person to threaten or use non-deadly force, but you've now become the deadly force aggressor, the first person to threaten or use deadly force. In effect, what you've done is started a second fight. They were the initial aggressor in the first non-deadly force fight. Because you've escalated from non-deadly force to deadly force, you've become the initial aggressor in a second deadly force fight. And because you're the initial aggressor in that second fight, you've lost the element of innocence, and you've lost self-defense as a justification for that use of deadly force in purported self-defense.
Pretty basic, kind of simple. Even though it's complicated, it's kind of simple. And I think once you understand these and you know them, then you can make those decisions probably quicker. You can make better decisions. So again, I know you said it before, but it is complicated, but it's really not. It's pretty simple. Some of these are pretty simple.
Well, I like to say that it's simple, but not easy.
There
So
you
there's
go.
only these 5 elements. They're not very complicated, but applying them to a real world fact pattern or to a real time conflict is not necessarily easy. Not because the legal doctrines are complicated, but because the real world is complicated. People are complicated. The world is messy. The facts are often ambiguous. So it's not clear often to the people who are tasked with deciding whether or not your use of force was in fact self-defense. It's not clear to them what happened. Remember, they weren't there, right? The police who come to the scene after the fact, naturally, you're never going to be attacked when there's a cop standing next to you. So the police who show up later, the investigators who investigate later, the judge, the jury, none of those people were actually there. So they don't know what actually happened. All they can do is listen to evidence, listen to witness testimony, and some of that may be true and some of it may not be true. The bottom line is, for them, it's ambiguous, it's unclear, and they have to make a decision. And you don't want to conduct yourself in such a way that you encourage them to come to a bad conclusion. For example, on this element of innocence, on this question of who was the initial aggressor, those of you who've studied fighting, jiu-jitsu, karate, boxing, anything like that will know that sometimes the tactically correct decision is to close with that other person, close distance, depending on the circumstances. That can be the right tactical call to make. Unfortunately, to people evaluating your conduct later, it never looks much like self-defense if you're approaching the other party, if you're going to the fight, as opposed to the fight coming to you. So you can end up with a conflict between what makes tactical sense and what looks like self-defense to other people who won't have tactical expertise in terms of who was the initial aggressor. It will look like you were the initial aggressor because you went to the other person instead of them coming to you. So you need to be aware of these subtleties so that you can credibly argue against them. So you can provide a rational explanation for why, although it looked like you were the aggressor, in fact, you were responding to an existing threat.
That's a great point. Great point. We had a question here from Eric Palmer. So as we get these questions, Andrew, I'm just going to rattle them off. Can deadly force be measured by an aggressor's physical ability, or the victim says lack of physical ability?
It sure can. So let's jump an element ahead to the element of proportionality. Proportionality has to do with the degree of force involved in the conflict. And then for use of force law purposes, the law puts force into one of two buckets. Either it's non-deadly force or it's deadly force. Now, deadly force obviously would include force likely to kill, but it's actually defined more broadly than that. It includes any force likely not only to kill, but also force that can cause serious bodily injury or grave bodily harm. Every state has a 3-word phrase for this. They're all different, but they all mean the same thing, something more than a minor injury. So the deadly force bucket includes force likely to cause death or serious bodily injury. But if you think about it, there's lots of ways to cause death or serious bodily injury. Obviously, a weapon designed for that purpose, a gun or a knife, would constitute a deadly weapon, an implement that can readily cause death or serious bodily injury. But a weapon's not necessarily required. You can imagine an attacker who's much larger than a defender or much stronger than a defender, or who has an exceptional fighting ability that the defender doesn't have, or there's numerous attackers. So there's a disparity of numbers that creates, in effect, in the aggregate, a threat of serious bodily injury just because you can't defend yourself against 3 attackers simultaneously. Traditionally, if there's a male aggressor and a female defender, a lot of those characteristics I just described are kind of baked in the cake. It tends to be the case that males are larger, stronger, and have a greater fighting ability than their female victims. That's not always the case, but it tends to be the case. So often those factors exist. The bottom line is the law, use of force law, doesn't really care per se if a weapon was used or an object was used, or it's just simply you were facing numerous attackers. The bottom line question in terms of evaluating what the degree of force was is whatever that threat was it a threat readily capable of causing death or serious bodily injury? If it was, it's a deadly force threat. And if it's a deadly force threat, you can use deadly defensive force to neutralize that threat. Where people tend to get into trouble isn't so much with the deadly force bucket if they're actually facing a deadly force threat. It's with the non-deadly force threat. So they're facing a threat that's not likely to cause death or serious bodily injury. Somebody shoving them, for example. And it's a genuine threat. It's a real threat. It's a scary threat. It's something they don't want to be subject to. Nobody wants to be shoved, but it's not a deadly force threat. And they respond to it with deadly defensive force. They respond to that non-deadly force threat. They respond to that shoving by going to the gun, which is a deadly force response. And now they're using deadly force to defend against a non-deadly force threat. What the law says is that's a disproportional response. They've escalated the non-deadly force fight to a deadly force fight under circumstances where deadly defensive force is not justified. So, go ahead.
Oh, just like somebody comes up to you, uses mace or pepper spray, and then you pull your firearm and use that. That's another example. That's not a deadly force, even though you may feel like that might be something you want to pull your firearm for. Probably shouldn't. But you could use mace or pepper spray on them in return.
Yeah, so things like mace, OC spray are an interesting special case, I would suggest, where it's really a different degree of force depending on whether it's being used defensively or being used offensively. Because if you're using pepper spray defensively, your only purpose is to neutralize that person attacking you and then to not continue using force against them. You're just trying to stop their threat. I would argue that's a non-deadly use of force because the pepper spray itself is non-deadly in nature and there is no successive use of force by you. Hopefully you're not pepper spraying the person and then kicking them in the head while they're on the ground. But an offensive use of pepper spray, I would argue, is different. If the pepper spray is being used offensively, it's being used to disable the victim so that further force can be used against that victim. And I would argue that disabling use of the pepper spray is in furtherance of a further use of force is in fact a deadly force use of pepper spray because it's causing serious bodily injury. It's causing disabling injury to further more criminal activity against the victim of that pepper spray. So I would suggest that if you're using pepper spray defensively, that's a non-deadly use of force. But if someone's trying to pepper spray you offensively to use further force against you, that would qualify as a deadly use of force.
We have some interesting questions. Well, here's one, and actually it's a couple of questions, and it's brings up something, and it's kind of off topic, but I do want to try to get to some of these questions. I know there's a lot of new viewers here. This one is the topic of dogs, right? And we talk about deadly force of dogs. Are they considered deadly force? If you have signs up at your home, beware of dogs, someone breaks into your house, your dogs chase them down through the open door. And I'm not real clear on this question, but I know we've talked a little bit about this dog situation and protecting your own dogs. If someone is threatening your dogs, if your dog is threatening somebody else, if you're being attacked by a dog, maybe we could talk a little bit about this. The question isn't very clear here, but it is a topic of dogs, so I want to just briefly talk about that because I know there's a little confusion on protecting your dog's life, and is a dog considered a deadly threat?
Yeah, so there's actually a lot of questions blended in there. If I were to put those questions in three different buckets, it would be how can I go about defending my dog from someone else's attack or some other animal's attack? That's one bucket. If I'm attacked by a dog, what force can I use to defend myself against that animal's attack? That's the second bucket. And the third bucket would be if someone's using a dog as a weapon. So it's not just some stray animal who's decided to attack you as you jog down the street. There's a dog's owner who's telling the dog to attack you. So they're using the animal as a weapon. What kind of use of force issues would arise there? Now, in terms of the first bucket, defending your dog from some other threat, well, your dog, as much as you may feel like emotionally he's a member of your family, as much as the humans in the family, legally speaking, your dog is simply personal property. And you're only allowed to use non-deadly force in defense of personal property. That's true everywhere in the U.S. except for Texas. Texas does have a provision for the use of deadly force in defense of property, but there's a lot of hoops and conditions you have to jump through to qualify for that permission to use deadly force in defense of property. And if you miss any of them, off to jail you go. So I would encourage people, even if you live in Texas, if you're defending personal property, and that includes items like a car or a laptop or a cell phone, and your pet from harm, you can only use non-deadly force in defense of that property. What if you're being attacked by a dog, say a stray dog on the street, you're jogging, whatever the case may be, and you're attacked by a dog? What degree of force can you use to defend yourself? Well, that's not really self-defense law in that scenario, because what self-defense law controls is under what circumstances can you use force against another human being, not under what circumstances you can use force against an animal that's attacking you. But arguably, it would be a separate legal doctrine called the Doctrine of Necessity that justifies what might otherwise be unlawful conduct as legally permissible if you're causing a small harm to prevent a greater harm. To give you an example of how the Doctrine of Necessity might work is you're walking down the street and you notice a baby in a locked car on a hot day with all the windows closed, and you realize if somebody doesn't come save this baby, it's going to die in that hot car. You don't see an owner around, so you break the car window to save the baby from dying in the car. Is breaking the car window unlawful? Well, normally, yes, of course, you're damaging someone else's property. But the Doctrine of Necessity would say the small harm you're causing is permissible because it's much less than the greater harm that's being avoided, the death of the child in the car. The analogy here to defending yourself against some stray dog is it normally unlawful to cause injury or harm to animals? And most jurisdictions have some kind of law against maliciously causing harm or injury to animals. So technically it's against the law, but if you're doing it to avoid some greater harm, that animal's capable of causing some maiming injury to you, then your use of force against that dog would be permissible. But it's not really under the doctrines of self-defense. It's under the doctrine of necessity, avoiding a large harm by committing a small harm. The third bucket is if someone's using a dog, an animal, as a weapon. And typically this would be a dog, often a large breed, very strong, powerful animal. Typically, very few people I know use Chihuahuas as attack dogs. So under that circumstances, that dog, under the immediate command of a person, should be treated as any other weapon being wielded by that owner. If he was trying to hit you with a bat or stab you with a knife or shoot you with a gun, those would all be threats of imminent deadly harm capable of causing death or serious bodily injury, deadly force attacks against which you could use deadly defensive force. The fact that he's using a dog as a weapon doesn't change that if the dog is similarly capable of causing death or serious bodily injury. Now, if he's sicking a Chihuahua on you, that's probably not a deadly force attack. But if it's a larger breed capable of causing serious injury or even death, that's a deadly force attack. And frankly, if he's wielding that dog, you'd be entitled to use deadly defensive force even against the owner to prevent that harm from happening.
Thank you very much. I hope that helped some of your questions. I know we covered quite a few topics right there, but I know it's good information. I know I get asked that question often as well. So I know we were talking about the 5 elements of self-defense law. I think we covered 3 of them.
Really? We covered innocence and proportionality.
And I thought we jumped ahead, but go ahead. Let's keep moving here.
Yeah. So those are really numbers 1 and 3. The second element is the element of imminence. Imminence has to do with the requirement that if you're using force against another person because they're presenting a threat, the threat they're presenting has to be about to happen right now or actually be in progress. You're not allowed to use force against another person because they committed some harm to you in the past. So they threatened you yesterday or they punched you yesterday. That fight's over. It's no longer an imminent threat against you. You're also not allowed to use force and attempt to justify it as self-defense to prevent a speculative future threat that might never happen or that's avoidable by other means. So somebody's angry at you and they say, well, I'm going to go home, come back in an hour and shoot you. Well, at the time they make that statement, that's not an imminent threat. That's a threat that may or may not occur in the future. Now, if they come back in an hour and try to shoot you, that's an imminent threat at that point in time. But if the threat's only going to occur sometime in the future, it's not yet an imminent threat against which you can use defensive force. So you can think of this imminence as being kind of a window that opens and closes. Before the window opens, before the threat is actually about to occur, you can't use defensive force to prevent a threat that's not yet imminent. After the window's closed, after the threat is over, someone's shoved you, but then they've run away, well, the window's closed then. They're no longer an imminent threat, even if they would have been earlier, and you're no longer entitled to use force against them because there's no longer a threat, an imminent threat against which you're defending yourself. So this is where people get in trouble on this element. They often get frightened by something, and they use defensive force before the threat that frightens them has become an imminent threat. So it's some kind of future threat, for example, that's not immediately about to happen, or they've actually were facing an imminent threat, but then the imminent threat ended. So the bad guy's running away, and they fire a shot at the bad guy as he's running away. Well, they might have been justified in firing a shot earlier in the confrontation, but once the bad guy's running away, that fight's over. The imminent threat is over. The privilege for using force to stop that threat is also over.
That's pretty understandable. I hope that makes sense to people. Has to be in the now. Can't be in the future. Can't be in the past. Has to be in the now.
Okay, so that covers innocence, imminence, and proportionality. The next element is the element of avoidance. And this is the most commonly waived element, although there is a catch to the fact that it's commonly waived. The element of avoidance has to do with whether or not there's a generalized legal duty for you to retreat before you can use force in self-defense. Now, only about 13 states impose that legal duty. So there's only about 13 duty to retreat states in the US. The large majority of US states do not impose this generalized legal duty to retreat, and they're properly understood to be the stand your ground states. You don't have a legal duty to retreat before you can act in self-defense, assuming, of course, the other elements of self-defense are met, that you have the element of innocence, imminence, proportionality, and so forth. Now, even the states that do impose a legal duty to retreat, they only impose that legal duty if safe retreat is possible, completely safe retreat. So you're not required to increase your jeopardy, increase your risk in order to retreat to meet that legal duty. Now, of course, this is often an area of ambiguity. One side might argue that there was a safe avenue of retreat, and the prosecutor on the other side might argue, well, there was not a safe avenue of retreat. And that's the kind of fact pattern that ultimately can end up being decided in front of a jury at a trial at a cost of several $100,000 to yourself. It's also true that in all those states, even the states that do impose a legal duty to retreat, there's also a legal doctrine called the Castle Doctrine, widely misunderstood, too broadly defined by most people. But in effect, the Castle Doctrine says that if you would have had a generalized legal duty to retreat out in public, you're relieved of that legal duty if you're in your home facing an intruder in your home. Now, I mentioned the vast majority of states, about 37 states, do not impose this legal duty. They're properly called the stand your ground states. But there's a little trick here, and that is in most of those states, in all but 6 of them, so about 31 states, a prosecutor can't tell a jury that they should deny you self-defense because you could have safely retreated and you had a legal duty to do that, because you don't have a legal duty to retreat in those states. So he can't make that argument that you violated a legal duty, because if he could and you did violate it, you'd lose self-defense simply as a legal matter. It would be off the table. But if he can't make that argument, what he can argue is, sure, there's no legal duty to retreat in this jurisdiction. We're a stand your ground state, but this defendant could have safely retreated and a reasonable person would have safely retreated, and therefore the defendant's conduct was unreasonable. And reasonableness is the 5th element of self-defense we'll come to in just a moment. But it's kind of a backdoor way of attacking your claim of self-defense for having failed to retreat from the fight, even when you don't have a legal duty to retreat before the fight, by arguing that your failure to do so, while not legally required, was unreasonable conduct, and therefore you fail self-defense because your conduct was unreasonable.
Andrew, there's been a couple of comments in one question about somebody who's disabled, and I think that the question, it's not really a question. We just passed it, Riley. It was just back up there a little bit further. Doesn't a disabled person have the right to defend himself against any kind of aggression? That's one of them, but there was other comments too. Somebody, I can't remember who was talking about having a back injury, but as somebody who maybe has a disability or a disadvantage and can't so much retreat, I don't know, where does that fall in line? The being disabled, not being able to retreat.
That's a great segue into the 5th element of self-defense, which is the element of reasonableness. So reasonableness is basically kind of an umbrella element that sits over all the others. Everything that you perceive, that you decide, that you do in self-defense has to be the perceptions, decisions, the actions of a reasonable person. So an unreasonable person, unreasonable decisions, unreasonable perceptions, unreasonable actions fail self-defense. Everything has to be reasonable. But what's that mean, to be reasonable? How do you evaluate that? Well, there's 2 components to reasonableness. One is an objective component, and that is, would a hypothetical reasonable person have perceived things the way that you did? And the jury's supposed to imagine now this hypothetical reasonable and prudent person and what they would have done in the circumstances. But the other facet of reasonableness is a subjective component. And that's where reasonableness begins to become customized for your particular characteristics and circumstances. So, for example, was there an absolutely safe avenue of retreat? Well, for one defender, there might have been, but for a different defender, perhaps not. If the first defender is young and athletic and fit, perhaps they could have simply have run away from the fight with complete safety, and that would have been a completely safe avenue of retreat. But a different defender who's older or injured or disabled, those exact same facts are different for that person. They can't simply run away from the fight with complete safety because they lack the physical means to do that. So what's reasonable for the fit person may not be reasonably required for the unfit person. The same thing can happen when we talk about proportionality, for example. So someone's threatening to shove you hard enough to knock you to the ground. Well, if the person being shoved is 18 years old and otherwise healthy and fit, being knocked to the ground is probably not that big a deal. Most of us have been knocked to the ground at that age, and we tended to bounce right back up. But I can tell you, I'm 55 now, and getting knocked to the ground, it's not quite so easy to get up anymore, or at least not as quickly. And if someone's, say, 80 or 90, getting knocked to the ground could cause a deadly injury, could cause a hip break, for example. So in that context, what would qualify as a deadly force threat, that shoved to the ground, could be very different for those three different defenders. Someone who's 18 and healthy, someone who's 55 and maybe has an artificial hip or artificial knee, someone who's 80 or 90 and would be prone to suffering a life-threatening injury if they were physically knocked to the ground. That's where this component of reasonableness comes in, and that's where this kind of customization comes in when people ask, well, what if I'm older? What if I have bad knees? What if, for all those kinds of variations in terms of physical abilities or disabilities?
I think that answers the question. Again, thank you. I hope that helps a lot of you understanding the 5 elements, the self-defense law. And if you don't remember all those, if you tuned in late, if you only heard a couple of them, you can go back one and watch the video. But you can also go to the website lawofselfdefense.com/CTS, just calling the shots, our show, CTS Elements. You can download that for free, and then you can reference that. And then when we're here in the future shows, and we're going to have you calling the shot, we're going to have some videos and stuff, and then you make the call. And you can see if those are met. We're going to ask you, we'll probably do some polls and things like that too. So we really want you to get familiar, not just for the show, but just for life in general. We hope that you guys all know where you're protected by the law. So if you are going to conceal and carry every single day, and you're going to go out into public and find yourself in the unfortunate situation where you have to use your firearm, you know that you're going to be protected by the law. Again, I always say distance is your best friend. Always avoid the situation. Andrew always has great points. There's 2 real outcomes. You know, you're either going to lose your life, or you're going to spend your life in prison. So you don't want any of those to happen. You want to save your life, and you don't want to end up in prison. As long as you're covered by the law, you won't. And
I always like to remind people too that, the moment you're engaged in that physical confrontation, and maybe it had to happen, maybe you couldn't avoid it, but the moment you're engaged in that physical confrontation, you've just incurred 2 risks you were not incurring a moment before. And the first is a greater than 0 risk of dying in that fight. And I don't care how good you are with a gun or a knife or your hands or whatever your preferred defensive techniques are, there's no way to reduce the risk of losing the fight to 0. You practice and you train to get the risk of losing as low as possible. And hopefully you can get it really low, but it's never 0. It could just not be your day, and you could lose that physical fight. And folks, the same is true of the legal fight, and that's the second risk you incur. Everything I teach, all the books I write, all these shows that I do, it's to help people reduce the risk of losing the legal fight to as close to 0 as possible. But the risk is never 0. I tell all the cases I consult on, I tell every client, If we go to trial, there's a 10 to 20% chance you're going to get convicted. And I don't care how innocent you actually are, because there's that much uncertainty in what a jury might decide to do. So you can't get the risk to zero. All you can do is get it as low as possible. Now, you should consider it your duty, your obligation to get the physical risk and the legal risk as low as you possibly can by training and practice and education. You owe it to yourself, you owe it to your family. But if you can avoid the fight in the first place and not have to incur those greater than zero risks, folks, that's the place you want to be.
Absolutely. Folks, the book, The Law of Self-Defense, which I have a copy of right here, is available as well. Make sure you get your copy of this. It is an inexpensive book, and it's very valuable. And I get all the time from people, man, you got to get this book. Oh, man, I love this book. Thank you, Nate, for tell me about this book. And it's, you know, it's not that expensive, and it's going to be so beneficial for you. I'm just telling you, you can find it on Amazon. You can get it at the lawofselfdefense.com, along with some other really cool things over there. But
and I would encourage people to take a look at it at Amazon, even if they'd rather purchase it someplace else. That's totally fine. But there are, I don't know, a couple hundred, maybe more reviews on Amazon. And folks, it's a solid 5-star rated book on Amazon.
there you go.
And we have very well-known names in the self-defense industry, guys like Mas Ayub, John Lott, Tom Givens, Mike Seeklander. These are all folks who are experts in this field of self-defense, who've read the book, extremely knowledgeable, and they're all fans and supporters of the book. It's easy to read. Most folks read it in an afternoon, Sunday afternoon. You can read the whole book. And the whole mission of the book and everything we do here at Law of Self-Defense is to help make you hard to convict. And that's not by teaching you legal tricks or loopholes in the law. It's by teaching you what you need to know about the law so that you can keep your conduct in self-defense within the legal boundaries. And if you can do that, folks, you are extremely hard to convict. If you can credibly claim self-defense to justify your use of force, the prosecution has to disprove your claim of self-defense beyond a reasonable doubt. Now, unfortunately, if you've done something stupid, you could make yourself extremely vulnerable to conviction by handing the prosecutor what he needs to meet that threshold, to overcome your claim of self-defense. But if you can keep your use of force, defensive force, within those legal boundaries, you are extremely hard to convict. Not 0% probability, but very, very low probability. And you can get yourself a long way there by reading one book in one afternoon.
There you go. Couldn't have said it better myself. Thank you, Andrew. I really appreciate it. I know everybody here, they love this show. They love the information. Love the book. Bertram Buddy says, I love the book. Can't wait to get my autographed copy. First thing I've ever won from Alien Gear. Well, Paul, congratulations. I know a lot of people will enjoy it, so don't just take my word for it. Listen to everybody else too. And it's a super valuable tool to have the knowledge that you need. Andrew Branca, thank you again this week. You know what? I think, ladies and gentlemen, Andrew's going to be at SHOT Show, and I slipped my mind, but I believe it may be Tuesday, 11 o'clock a.m. Pacific time, where you and I are going to be meeting face-to-face and doing a live show from SHOT Show next week. So that would be cool. Make sure you're tuning in. And I want to remind everybody who is watching right now, not only do we have a show tomorrow, the raffle, you need to get signed up at aliengearholsters.com/contest, and we'll be back live tomorrow to do the raffle. But there's a little notification button.
Whoops. Did we lose Nate?
This is Andrew Branca from SHOT Show in Las Vegas. So make sure you're tuning in all week long. That's it for today. Got more comments. Awesome show. Love calling the shots. Andrew, you are the man. Great show. Thanks, Andrew and Nate. We just appreciate all of you for tuning in. We wouldn't be here if it wasn't for you. So please share this video. Actually, if you share this video, one of you is going to win a book. I'm going to give one of you a book. All you got to do is share the video. How about that? Thank you, Andrew. Thank you all for watching. It is calling the shots here at Alien Gear Holsters Live. We'll be back to do more of these in a couple of weeks. We're taking next week off. But thank you, Andrew, for being here. We certainly appreciate it.
Before we go, Nate, I just want to, for anyone in the audience who's attending SHOT, if you happen to see me at SHOT, feel free to come up, say hello, shake my hand. If you've brought a book with you or something like that, I'll be happy to autograph it. I won't be hard to spot. I'll probably be the only guy there not in camouflage, wearing a warrior suit.
Perfect. Thank you very much, Andrew, and thank all of you for tuning in. We have more to come. We'll see you back here tomorrow. From all of us at Alien Gear, please carry safe, carry in comfort, and carry on. Cheers to a smooth new year. Alien Gear Holsters wants to help you kick off the new year snag-free with the new Sig Sauer P365 SAS. One lucky winner will win a Bigfoot Gunbelt, a Tactica tactical laptop bag, an Alien Gear shoulder holster, an AlienGearIWB holster, and the Sig Sauer Anti-Snag P365. Win these prizes by entering now at aliengearholsters.com/contest.